You're recognized. Hi.
Senator Huffman and members of the Senate Committee on State Affairs, thank you for having me. My name is Chelsey Youman, and I am legal counsel with First Liberty Institute. First Liberty Institute is the largest organization in the country dedicated exclusively to defending religious liberty. Because First Liberty is headquartered in Plano, Texas, but represents clients in religious liberty matters across the country, we have a unique perspective on the religious liberty rights landscape, both nationally but also in the state of Texas, both where we've done a great job protecting religious liberty interests and where there's room for improvement. Texas RFRA is an important tool in defending religious freedom in Texas. However, it is not the last word in religious protections because, after all, it is a balancing test where judges balance the interests of the state and the religious burden placed on religious adherents. Because of that, we have a very, very vast and diverse jurisprudence where in some cases and in some circuits and in some districts, judges will rule on the side of the religious adherent, and others they'll rule in the exact opposite way for the government. The solution that several states are now attempting to solve this problem is by crafting specific protections instead of a general one-size-fits-all protection that RFRA is. For example, last session, Texas implemented the specific protections in the context of protecting child welfare service providers, HB 3859, which you have heard about previously. Because of this enactment, many nonprofits like Bethany Christian Services, Catholic Charities, and Lutheran Social Services may continue to place children in homes in accordance with their religious beliefs and may continue to operate in the state. By setting bright-line rules on particular topics, legislation also ensures that both religious adherents and government officials know what is and is not protected religious conduct. The uncertainty of hoping a judge will weigh the balances in your favor so that you can follow your religious beliefs is removed. And specific legislation like this also reduces litigation costs and creates a uniform legal system. As I mentioned, we are actively defending religious liberty matters across the country. I have a front row seat to many of the anti-religious liberty trends that are occurring. I will now turn to specific religious liberty and conscience protections Texas should take the lead in enacting to address these troublesome trends. The first is religious staffing. We could use Indiana SB 127 and the Russell Amendment as templates to pass legislation that will protect religious staffing rights of faith-based organizations, both broadly and those who contract with the state of Texas. The Supreme Court held in Trinity Lutheran this past summer that entities should not have to choose between their religious identities and receiving a generally available government benefit. Although these types of protections affirm existing employment provisions under federal and state law, we are finding that many states and federal governments are forcing religious organizations to compromise on their religious values and beliefs in order to contract or even subcontract with the government. The second area would be a broad occupational license right protection or healthcare conscience rights protections. Enacting religious conscience protections for professionals across our state would have immeasurable benefits. A diverse measure that would provide multi-issue conscience protections for from both individual claims and governmental discrimination would be preferable. For example, this bill would enable therapists to provide counseling in accordance with their faith. It would provide a counter to Stormans versus Wiseman, the case out of Washington where a pharmacy was held liable for declining to provide abortifacient drugs. And it would also protect healthcare professionals in nearly every field from discrimination due to their beliefs on beginning of life, end of life, and fertility issues. Third, a bill like the Texas Interstate Commerce Improvement Act would be important to us to the extent that it protects religious liberty as a class and their rights from being diminished by local entities. There is a massive need for continuity across the state of Texas in this arena. I receive dozens and dozens of phone calls and advise each client differently in our state on this issue. Each local precinct, ordinance, city, and county have their own laws, rights, and remedies. Some include religious exemptions, some do not. Those with religious exemptions are awfully woefully unconstitutional and would not pass constitutional muster. For that reason, I think it would be really important for the citizens in our state to understand what their rights are and are not, and what their protections are and are not. Finally, I would posit that we should pass faith-based pregnancy center conscience protections from local government encroachment. Although the occupational code protects healthcare professionals from participating in abortion, it does not address other professional conscience concerns such as beliefs pertaining to end of life and fertility. Further, it doesn't protect religious healthcare providers from government discrimination. At First Liberty Institute, we proudly represented pregnancy resource centers in Austin who had to succumb to an unconstitutional and discriminatory ordinance that the city of Austin passed, where they required these only pro-life pregnancy resource centers to post up a sign in their parking lot that said, "Warning, we don't have medical professionals on staff," which, as you can see, is extremely targeted provision. But that is not a lone wolf. We see this across the entire country. Austin ultimately had to pay $500,000 in a settlement in this case. So truly, this would be a great way to save the state some resources, I would think. Finally, it should be noted that conscience protections for religious dissenters is the rule in American tradition and not the exception. First Liberty filed an amicus brief in Stormins that recounted the history of conscience protections. I promise I won't go into that history today, but the brief included 60-page appendix of federal, state, and territorial statutes and conscience protection rights of not just healthcare professionals, but all who don't want to violate their religious belief, but also serve the public, including abortion, assisted suicide, contraception, and capital punishment. I think that rationale applies with equal or greater force to conscience legislation passed in dozens of states today. Thank you for the opportunity to testify, and I would be happy to provide many, many more examples of both my clients, what I've experienced in the practice of First Liberty, and I'll be happy to answer any other questions.